Hey, I'm Marc Stevens, author of Government Indicted, the website markstevens.net. Glad to be with you here live from the fortified compound in Mesa, Arizona. It's May 24, 2017. This is the 21st episode of the live Wednesday show. No commercials. Because, hey, people are just lining up to sponsor a show that attacks what people would think was the very fabric of society. Actually daring to challenge the unchallengeable, to refuse to accept sacred cows. That's what we do here on the No Stay Project. We do it 4 hours a week. So if you want to join me on the big show, it is 218-632-9399, 218-632-9399, with the passcode 2020. That's 2020 with the pound sign. And let's talk more about court procedure here today. I tell you, there are some people who just can't stand finding out that what they thought was real is nothing more than a public relations scheme. They think counties and cities and states and citizens and governments, they think these are real. Oh, maybe it gives them purpose. Maybe it fills their bank account. I don't care. Because these people are typical of those you cannot reach. They really are the ones that no amount of evidence is going to change their mind. Usually these people have a vested economic interest in such a belief system. Maybe they have stock in Halliburton, CCA. Maybe they got family in the military. Whatever the reason, there is going to be, and unfortunately it might actually be a majority of people, no amount of proof is necessary. They believe things without proof, but then claim, illogically, that if you want to prove them wrong, you need evidence. Now, if they don't have a gun and they're not threatening you with a prison system, you could just brush this person off as the illogical fool that he is. Because I would hope that rational people aren't going to be taking them too seriously. But if they have a title, yeah, then they probably do. So on one of the recent videos, we've got a new troll. The guy has to be getting paid. So on the last video we did, the No Stay Project for May 20th, where I discussed cross-examination, court procedure, of course, like we always do, teaching people and giving them the tools to defend against these bogus charges. And while Charmaine may have called into the show and gave us a report, if you go back into the videos, into the articles on markstevens.net, you will see the actual documentary proof to back up what he said on the show. But that's not enough for these internet trolls. And I know new people under stress just coming to the material may see these. Look at all the evidence. Look at the proof. Don't just take it at face value, because chances are if someone's saying, I've never had any success, they're lying through their teeth. This is a great one. Stevens is a loser and a liar. He nor anyone else has ever won anything in courts using his concepts. Why? Because they are absurd and have no basis in law. He has a long string of losses, though. He won't tell you because he's a fraud and a liar. His main idea, challenging jurisdiction, and get this, he claims U.S. courts have no jurisdiction, period. Good luck with that, bud. So they point out that there's a whole success story on the website, and he just keeps saying, I'm a fool, I'm a liar, I only fool the fools. It doesn't matter about the evidence. Now, a moron calls in and tells a tale, you call that proof. Yeah, but there's documentary proof to back it up. So, yeah. And the wannabe doctor has zero proof Stevens' BS is real. Hint, it's not. Wow. So he won't. All right. He has a long string of losses, though. He won't tell you because he's a fraud and a liar. I unfortunately have to talk about one of the bad things again today, and I've never shied away. We have I don't screen calls. I don't have there's nobody screening calls here. So it's not as if anybody who's lost really bad can't call and say, you son of a, you bastard, you claim this was effective and it was a train wreck for me. We have people calling all the time with that. Unfortunately, our friend Bill Paisan is nearing the end of the attacks against him. Had a very bad day today. Dog and Pony Show in an administrative hearing up in New Hampshire, not allowing cross-examination. And so, yes, that was a crushing loss, unfortunately. But we are dealing with psychopaths. Now, some may say, well, Marc Stevens just uses that as an out. He only says that. He says that to cover himself when you don't win. We say that going in. And for the critics, you have to keep something in mind here. Especially me, I'm coming from this from an anarchist standpoint. I see absolutely no validity whatsoever, zero validity to the legal system and what are called governments in general. And I have evidence to back that up. A lot of evidence. They are criminals. They are a criminal organization with no legitimacy whatsoever. The evidence is, and it's irrefutable, they're men and women, and they force everyone to pay them. That's it. That's it. If you got a problem with that, try to disprove it. Very easy for me to prove it. Hell, I've got Scott Bales, the Supreme Court Chief Justice here in Arizona, on record. The reason why the laws apply is because they put other people in prison. We have a prison system. If you don't comply, you go to jail or they kill you in the process. Irrefutable. These are the facts. So we're not just going in and challenging the ticket. We're challenging the concept of government itself. So this idea that we can't use logic, we have to use legal logic. No. When you go in there, you're dealing with criminals. And you should not limit yourself and limit your defense. Why wouldn't you use every peaceful method available to you to show that these are grossly unfair? Would George Bush sit still for a second if he was charged with war crimes at The Hague? What would he do? What would his team of lawyers do? They would argue that the court has no validity. So, like it or not, there's a valid legal defense there. Even legal is to not recognize that the court or the government has any legitimacy at all. Hey, a lot of dictators have done that. Milosevic, that was his defense. That's what was the Nazis' defense. I'm not defending what they did, but it is a recognized offense. So this idea that I'm a fraud, don't just say I'm a fraud. Why don't you call into a broadcast and present your evidence? So when I say that they're a criminal organization, I got the proof. I got the goods. We got the goods on them. I have a sitting city councilman on record saying they have jurisdiction because they say so. Criminal. Absolute criminal. His main idea, challenging jurisdiction, and get this, he claims U.S. courts have no jurisdiction, period. Good luck with that. Well, in practical terms, yeah, There's not a shred of evidence to show that their laws apply to anybody. Anybody. No evidence. There's some prima facie evidence as far as people like the president and governors. Prima facie only. Breaks down under scrutiny, as most of their claims do. Good luck with that. Now I'm going to put this up on the. I'll put that up in the video so you won't see this, but maybe for the live broadcast. This is actual proof. This is actual proof from our friend Ginger, and I'll get this in the video, and I'll have a separate video about this. State move to dismiss for insufficient evidence. Yeah, even when we show that the motion I wrote is granted, they still lie. But you got to expect that. They accuse me of lying, but you show them the proof, and Ginger said we can do this unredacted. Okay, we can do this unredacted, so that'll be in the video. Yeah, never had any success. Okay, keep telling yourself that. And if you're investigating my material and you're under attack, or maybe soon, and you want to learn an effective way to defend yourself, the success stories just keep growing on 3 continents also, by the way. So when you get it's a well-known thing. YouTube comments are horrible. Yeah, YouTube comments are some of the worst. So you take them with a grain of salt. Look for the actual proof itself. That which can be asserted without evidence can be dismissed without evidence. And so I bring the evidence to the table. But there are criticisms, and that's fine. But at least if it was a legitimate criticism, to turn around and say we've never had any success is just wrong. So even with Gingers, they could say, well, it could have been for other reasons, not because of jurisdiction. Well, we're not just arguing that there's not evidence of jurisdiction. We're saying that there's no evidence of a valid cause of action. There's not sufficient evidence here to set forth a valid complaint. They pushed him pretty damn hard to deal or go to trial. And then all of a sudden, another prosecutor dismissing for a lack of evidence. So look at the circumstantial evidence. We file a motion to dismiss for no or insufficient evidence, and it gets denied without explanation. Prosecutor files a motion to dismiss for insufficient evidence, it gets granted. Yeah. But through the whole thing, you'll find one common denominator there. In no instance do they actually present the evidence we say is missing. So the best the critics can do is say that they don't need evidence. And when you hear that, you know you're dealing with an intellectual giant here. You're talking to somebody who has a lot of confidence in criminals and the organization called government. Because they got a prison system. That's their thing. They got a prison system. And people who say that they can argue without evidence and that you need evidence to counter that, they can be so confident because they're willing to hurt you, or they'll post online about how much they get their jollies off and how they've jerked it to hear that somebody was punished by the courts. They just seem to love this, these sadists. So have people lost? Yeah, and I've discussed it on the show. I know all about Marc Edwards. We've discussed him many, many times on the show. I also have, from Marc Edwards, the fact that he never paid a cent, ever. We also have Gary Murphy from the Internal Revenue Service stating not to take phone calls from Mark Stevens because there's over 24 calls to the agency on the website, markstevens.net, that are very embarrassing. And the document is on markstevens.net. You can look it up. You don't take my word for anything. Gary Murphy, an internal memo to the IRS, don't take calls from Mark Stevens because they're embarrassing to the agency. Yeah, I know. Some may say, well, they embarrass the agency because Marc is actually a retard and they can't, they don't like having to, deal with somebody who's functionally illiterate and is retarded. So they feel it's embarrassing that the agency made Marc Stevens look so bad. No, it's because I'm asking basic questions that they should be able to answer. Asking for evidence to support their claim. So keep in mind, when you're coming at it from a standpoint of the evidence that you can actually prove, and you're not taking a damn thing on faith, or because you're in fear, because they're going to carry out their claim that they're going to put you in prison if you challenge them, or that their laws apply to you because they're willing to put your ass in jail. You have to realize this is radically different than a typical defense. Well, no attorney would do that. That's not true. I work with one that got disbarred. But attorneys don't do it because they don't want to piss off the judge. I've spoken to them. I know one. He's a damn fine attorney. Jack Pointer, Oklahoma City. And he was one of many attorneys that explained this to me. I'd love to be able to do what you just did in there. But I have to work here. If I piss this judge off, he'll make my life miserable. I won't be able to defend my clients. So, this is the basic thing that you want to look when you're going through and framing a defense. What I think is a very good tactic, and I keep mentioning this, because we have a lot of new people that keep listening to the show and tuning in every week. You absolutely have to zealously challenge the claims that are being made against you. That's how you defend yourself. You have to challenge the arguments and claims and allegations being used against you. You cannot give the prosecution a free pass. You absolutely should not do that. And anyone who tells you the prosecution should get a free pass, especially in a malaprohibitive situation, is steering you in the wrong direction. And I have never spoken to when I've asked attorneys, seasoned litigators, when I brought that up, and I've asked them, should you give a prosecutor a free pass on an allegations he's making against your client? Hell no. Hell effing no. You absolutely do not make the prosecutor's job easier. And then the one where they all have the conniption, where they contradict themselves. Because remember, we're bringing out the contradictions. We're showing they cannot prove. That's why they say, we don't have to. Fungal, you don't have to. Fungal, you don't have to. You immoral degenerates. And what they've done to Bill, who is not accused of doing anything violent, not hurting anyone, where they admittedly have no evidence. And they still went after him anyway. Dishonest. And you bring out those contradictions by asking questions. So the third part of this tactic, this general way of defending yourself, is you prioritize the claims that are being used against you. There are some that are more important than others. There are some that set the relevance for the others. And the mother of all relevance proving claims. If you are physically in Arizona, our rules apply, and that gives us jurisdiction to do this. Otherwise, they even agree, if they didn't have the sacred law, they would be criminals, doing exactly the same thing. That the only thing that sets them apart from a garden variety crook is the law. These sacred pieces of paper that magically apply to everybody. Why? What did Colby say? Because we said so. And to turn around and say that I'm a fraud because I actually support what I'm saying, and defending people that say, because we said so. That's why you just, look, 218-632-9399. 218-632-9399. The passcode is 2020. Bring your evidence. I actually invited this latest troll to come on the show, and of course they usually don't. Because like that one that came on, they just embarrassed themselves. And then they sit down and all over the keyboard thinking, oh, I got him. I got him. So when we are using these principles, it's very important to keep in mind you're just trying to get them to verify their claim. That's it. If they could prove their claim against you, they would. They just present the evidence. They would give you the name of a witness or personal first-hand knowledge. They wouldn't impeach their own witness. So what I want to talk about cross-examination, and I'll have to still do a separate video for that, because it's a huge topic, it's a very important one. So if you are going to defend yourself, you absolutely need to learn how to effectively cross-examine a witness. It's not nearly as difficult as some would have you believe. We are generally working with anarchists or people who are very peaceful. We're talking about mala prohibita. We're talking about non-compliance. They don't like it. You did not comply. We're not talking about real crimes. Mala and se are real crimes. They are crimes that by the time we're 5 or 6 years old, we understand are wrong. We don't need some scumbag politician in Phoenix or D.C. or Ottawa to tell us that's wrong. Apparently, they don't realize it's wrong as applied to them. They think stealing, killing, cheating, lying, all that's okay if you call yourself a government. But if you're not a government, then it's wrong. Well, yeah, we all understand that's wrong. So fungal with your double standard. So realize it's all you're doing. If you take the burden of proof upon yourself, if you start asking or making affirmative statements, now you're taking a burden on yourself. You have to prove that. Anyway, so we're only trying to bring out the contradictions. That's it. And we do that by asking questions. Who, what, where, when, why, and how. Your why and how are very, very important. So I say 1,000 times, it doesn't matter what somebody comes out with. If you stick to those questions, those types of questions, you're going to be able to come up with one that's going to be appropriate to call out somebody's BS. Yeah, this is where the role-playing comes in very, very handy. Very handy. You need to do that. You need to understand these basic principles so that you can engage other people so that when you do get into the lion's den, you won't choke. So, some of the things that you can expect that you need to focus on in role-playing, like what they did to Bill. You know how criminal these people are, not just because they're forcing everyone to pay them, but when you get into it's supposed to be a fair hearing, and they won't let you cross-examine the witnesses, right? Now, cross-examination, for those who don't know, is a defense tactic, generally. When a witness is put on the stand, let's say by the prosecutor is going to ask them questions, and those questions have to be, except in very limited circumstances, they have to be open-ended questions. They cannot be leading questions. They can't be yes or no typically. So they have to ask questions on what's called a direct examination. Once the witness is done with it, the prosecution is done with the direct examination, then the defense, or if it's a defense witness, can do a cross-examination. In the cross-examination, I'm going to keep saying this, all your questions should be leading questions. Pretty much every single question should be a leading question, meaning the information you're trying to elicit is in the question. You're leading them to a certain point. We're leading them to a contradiction, depending on what claim that they've made. So a leading question is, after you got to the defendant's house, did you go inside? So you're leading them to a certain point. What happens with us, because there's no evidence, these so-called fair, impartial, independent decision makers have to lie about what you're limited to on cross-examination. Let me make this perfectly clear. Cross-examination is not the same as a direct examination. You have far greater latitude. They don't say that the sine qua non or the be-all, end-all of a trial is the direct examination. No. The be-all, end-all of a trial is the cross-examination. Competency and credibility are always at issue. You just have to show that the question is relevant. Relevant. Is it relevant to prior testimony? Is it relevant to proving competency and credibility? Is it relevant to what he's testified to on direct? That's the criteria. Is the criteria, it goes against the judge's political beliefs? No. But that's exactly what they do. So remember, when it comes to disqualifying a judge, it's not supposed to be based on something that came up judicially. It has to be an extrajudicial or a non-judicial source of bias. His political beliefs are not necessarily judicial, and therefore coming into the proceeding with a hardcore, unbendable, irrefutable presumption or belief, you can't possibly get a fair trial because he's not going to let you defend against it. So what they do, like they did to my paisan in New Hampshire today, Bill, they deny you an effective cross-examination. And they'll say to you, like with a police officer or a prosecution witness that was aiding in the investigation, he or she's acting as a state agent, they'll tell you that they are only there to testify to the facts. And this is one of the biggest lies these degenerates will tell you. No. Objection. You know that's not true. Competency and credibility and all prior statements are a part of a relevant, effective cross-examination. I can't tell you how many times people have told me that. We have the lie that jurisdiction is a trial issue only. That is told constantly. Another one is that the witness is only there to testify to the facts. Why is the police officer on the stand? Who started this whole mess in the first place when a mala prohibita but the damn cop? I am sick to death of hearing these lies, and more people need to confront them on this. The cop, to put him on cross-examination, all of his prior statements that are relevant here are the subject of an effective cross-examination. And if that degenerate with the black robe says or sustains an objection or does not allow you to question them on that, they are denying you effective cross-examination. Brookhart versus Janus, I think, is the Supreme Court case. A denial of effective cross-examination without waiver would be a constitutional error of the first magnitude, and no amount of showing of prejudice would cure it. And yet they do it almost 100% of the time. They did it to Bill today with every single witness. This administrative hearing officer was so absolutely certain that these laws, these magical laws apply to Bill just because he was physically in New Hampshire, that he took the drastic step of committing one of the worst errors a hearing officer or judge can commit, and that is denial of effective cross. If your position is so strong, everybody knows the laws apply, Mark. You're an idiot. Why do they not allow the witness to testify? Why do they consistently deny effective cross? If the police officer made the determination of probable cause and that the laws applied and that there was an alleged violation, guess what? That statement, that mindset, that thought process he went through to bring you into jail and force you into these proceedings at the behest of his partner, that scumbag with the robe on. And guess what? That's relevant to a cross-examination. And if you have any decency, any honesty at all, you can say anarchy is ridiculous. But there's no possible honest justification for not allowing someone to cross-examine a police officer on prior statements, such as his determination of probable cause. Probable cause is a legal issue. The cop is making that determination on a street. How many times do we have to say that? Because they know it's true. The judge absolutely knows that is true. He's only doing that to keep from the witness embarrassing and blowing the prosecution's case. So when you determine probable cause, you did it because you saw me physically in New Hampshire. And because I'm physically in New Hampshire, that means your laws apply. Yeah, and that gives you jurisdiction to investigate and determine probable cause. They allow that question to be asked and answered. But the moment you ask that piece of garbage, the moment you get there and you ask him, do you have any proof that that allegation is true, that that claim is true? They can't deny you effective cross-examination fast enough. And I know nobody wants to hear this. We have had success on appeal, regardless of what these petty YouTube, trolls think. And it's at markstevens.net. We have prevailed on denial of cross-examination. We have prevailed with the prosecution has not met their burden of proof. It's one of the worst errors they can commit. And the best that I can offer you here is if you can't win on a denial of effective cross-examination, it's because you're in a rigged game and they don't give a damn about the appearance. They don't care. Because forcing people to pay you means never having to give a damn about honesty, integrity, and fairness and due process. And that's what you will find in a cross-examination. A lot of times that's the straw that breaks the camel's back. You see, look, we are going in there to make it absolutely impossible for the judge to make this look fair. Unfortunately, like this criminal with Bill this morning, the guy didn't care. It's just like the psychopath Michael King in New Hampshire. They don't care about whether it looks fair or not. They want to be able to say he had a hearing. Because in the average idiot's mind, that must mean you're guilty if you lost. Because the average moron walking around out there thinks trial equals fair trial. Even lawyers with the Innocence Project would beg to differ there. How many people are falsely convicted and DNA evidence shows that there wasn't any possible way? And how many times do we have to discuss the Brady epidemic, the Brady violation epidemic, willfully excluding exculpatory evidence, not giving evidence that shows innocence to the defense. I am not making this up. It's at epidemic proportions. An appellate judge named Kaczynski wrote that. If it's gotten so bad that an IRS bootlicking scumbag like Kaczynski is saying it's bad. Imagine what the extent of it really is if Kaczynski is saying this. It's got to, because I could tell you from my own experience, almost 100% of the time they have violated Brady. Almost 100% of the time. Because when you have the cop on there for cross-examination, remember, you have already objected to him being on the stand, which you dang well should, because he doesn't have personal first-hand knowledge of what he's testifying to. How could he? What the hell is he going to say? Mr. Police Officer, did you determine on your own that the Constitution and laws apply to me just because I'm physically in Arizona? Yep, and that's the basis of your jurisdiction? Yep. Do you have any proof? Yep. Would you care to share it with the room? Yep, the evidence proving the Constitution and Code apply to you, Marc, is all the other people I put in prison. Now, if that was a legitimate answer, why did they deny the cross-examination? If it was a legitimate answer for them to say, I don't have to, prove that, you idiot. If that was a legitimate answer, why don't they just let him say it? No. Instead, they deny you cross-examination. So if you're in that situation, object and point out, sir, aren't you denying me effective cross-examination? He may say no. How is a question going to his prior statement? And I mean a prior statement in that it was 30 seconds ago. How is my follow-up question not relevant? This is why when people criticize what I'm doing, they're doing it. I'm going to give some people the benefit of the doubt. They're doing it from a very, very narrow focus. They're doing it under the expectation or under the guise that the system is valid, that there are just a few bad apples. And you cannot examine the work that I do in that light. Of course it's going to look ridiculous to you. Of course. You have to take the blinders off. You have to look at it from the same perspective. You have to accept the facts that we can all prove on our own. They're just men and women forcing us to pay them. Oh, but Mark, they're more than just that. They build the roads. They have Medicaid. They have this. They got that. They got the military. That's completely irrelevant. They're forcing people to pay them. That negates any good they may be doing from that point. It's the same thing as with an animal that's so-called free range. It had a good life before I slit its throat. What are you bitching about? Holy crap. The slitting of the throat's the problem. Forcing people to pay you is the problem. If you have an issue dealing with that, maybe you should speak to a qualified professional just to find out why you have such a callous disregard, or find out why you're delusional. Why you have you don't have a moral issue with forcing people to pay. I'm talking about forcing strangers to pay on the threat of hurting them. But these are the truths we have to have. That is what is framing our perspective when we're forced into these proceedings. That's what's going to govern our questions. That's why when you understand that and you look at the questions on cross-examination, when you hear the statements that they make in response, you'll understand, because bottom line, what they're trying to do, they're trying to hide the gun under all that paperwork. Now, obviously, some of them, like Bill Montgomery, just doesn't give a damn. He'll just come flat out and expose the gun. You don't do what we say, we will use a gun to get our way. You either comply or we'll force you to, we'll make you comply. Not all of them are willing to do that. They don't want to. Like I said in Adventures, they do business at the barrel of a gun but claim to be fair and impartial and be administering justice, which is why we can get things like this. Again, I will have the HD version. I'll put it up in the video as a graphic so you can see. But that's why we get this. Ginger made it so difficult for that prosecutor. And there's some, Charmaine called, he went through 5 or 6 prosecutors. They just kept on not wanting to deal with it. You make it so difficult for them to make it look good, to make it look fair. But they do the right thing eventually. Because they do most of the time still throw all this crap out. So, getting back to the cross-examination, remember, contradictions. Inconsistent statements also. This is what asking effective questions in cross-examination are going to bring out. And don't treat the police officer any different than the judge or the prosecutor, or when you go to the city council and you're asking these questions. You're respectful. You don't talk over them. You let them answer. But if they start not being non-responsive, objection, move to strike non-responsive. Limit the question, your answer, if you're going to answer, limit it to yes or no. You can object if he's trying to give a narrative. Objection, narrative, just please instruct the witness to just answer the question. This is my cross-examination. You already had a direct examination. If there's something you want to bring out, if there's a damn narrative that you just feel compelled to get out, then your attorney can recall you. But then you get an opportunity to redirect, to go and do another, after the redirect, you can still ask more questions on cross, depending on what he has said, especially if he's bringing out new information, especially if it's going to contradict. But I cannot underestimate to you, and I don't think anybody legally would. The Supreme Court certainly hasn't. in writing, not necessarily in practice. The cross-examination is critically important. Know that your skill at the cross-examination is going to cross over for your skill at a motions hearing. Now, yeah, okay, that's where you're dealing with a bit different, where they'll say, I'm not here to answer your questions. That's a huge one. The judge may say, I'm not here on the cross-examination. Does the prosecution have the evidence or not? That's not part of a cross-examination question, you narcissistic dress-wearing bitch. Seriously. I'm not here to answer your questions. Isn't that something, you imagine a little bitch would say? If the prosecution had the evidence, damn it, they would just tell you, sir, it's right here. There isn't evidence. Like so many times, if there was proof, damn it, they would just provide it. I guess I can just, Socratic method of just asking questions. You're in a fight here. I have never come out and said that going into court is easy, nor is it even desirable. I never want to set foot in court again. I hate those places. They got a bad vibe to them. The people in there are typically narcissistic or borderline personality types who have very, very poor coping skills. I'm not here to answer your questions. Well, the fact that you forced me to be here, yeah, I can see that. You're not a guy who likes to be questioned. And that's another thing, too, that I want to bring out before I end the show here. I'm probably going to end this early for that. You know what? I think what I'm going to do is I'm going to wrap up the show right here, and we'll get the evidence in the video. I'll do a separate video with more information about how Ginger went about getting that tossed out. But the information is always available, of course, on markstevens.net. We have the proof. If you think I'm a fraud, if you think I'm a liar, don't just accuse me of that. Prove it. Actually, prove it. We do a live broadcasts every week, sometimes a lot of times twice a week. You're more than welcome to call into a live broadcast and show me up. Show me for the liar that I am. If I'm lying, there'll be proof. It's all on my website. You could use it all against me. So far, no one has been able to show that I have been dishonest one time. And I've been doing this a long time. That's the thing of having something like 10 gigs worth of audio on the website, plus all the articles and whatnot. If I lied, if I was dishonest, somebody would be able to produce that evidence. So take it with a grain of salt and do your investigation if you see comments and criticisms like that. And again, remember Hitchens' razor here, everybody. This applies to everyone. Isn't that part of a movie? Maybe I'll put that, Gary Oldman. Yeah, everyone! That which can be asserted without evidence can be dismissed without evidence. If you don't have the goods to back up your argument, then have fungal and you walk away. Someone tell me why I should take an argument with no evidence. Why should I take it seriously? No one's going to take mine seriously, as they should. But if you disagree with what I presented here on the show, if you believe I'm a liar, if you think I'm a fraud, you think I'm being dishonest, you think it's never been successful, then call into the show with your proof. I'd love to hear it. Again, my name is Marc Stevens. This has been episode 21, the live edition of the No State Project here on Wednesdays. It's May 24th, 2017. We will not be live this Saturday, but we'll be live again next Wednesday, and hopefully we won't have an audio problem. But till then, salud.